One is suited to war crimes like the one issued here. One is suited to conventional prosecutions. And it is not an act of machismo to take a trial that belongs in one and to put it in the other. And then we come to the showing that we're a law-abiding people. Of course, where there was no other forum, we have tried terrorists in civilian courts before, including Omar Al-Rahman, Sheikh, Ramzi Youssef, the mastermind of the first World Trade Center bombing in 1993, and was planning a series of airliner bombings that would have happened if he hadn't been caught with some explosives he was working with, detonated accidentally as a partner in Manila, as well as the perpetrators of the embassy bombings. So the world doesn't seem to have been impressed with those trials, at least not to the point where 9/11 didn't happen. The folks who perpetrated that were not impressed, nor were people who perpetrated the bombings in Bali. It's difficult and problematic as that whole situation is. We've had yet another incident where regrettably was driven off the front pages by the announcement last week, and that was the massacre at Fort Hood, apparently perpetrated by an Army major, psychiatrist who administered soldiers was at Walter Reed before they were sent to Fort Hood, and who subscribed to a militant faith that led him to use what was supposed to be professional lectures to advocate attacks on the United States troops, cast accusations against them and their mission. Some of them communicated by email with a known al-Qaeda recruiter, a cleric who praised suicide bombing and fanatical opposition to this country and all it stands for. And someone just before he began his assault got up and shouted, "Allah Akbar," Allah is a phrase with which we have become depressingly familiar, at least since September 11th, if not before. How do we get here? In 1946, George Orwell wrote a remarkable essay called Politics in the English Language, which I used to require my law clerks to read before they took up their duties. He wrote that essay just after World War II, when the nature of Soviet communism was becoming clear to anyone who had the eyes to see and the ears to hear. And his thesis was quite simple. It was that language influences our thoughts and politics, and vice versa, and that when we permit sloppiness and apparently benign abstraction to infiltrate our language, sooner or later they infiltrate our politics as well, and that when we try to justify things that can't really be justified at all, or to refuse to face things that have to be faced, we start to resort to language that then conceals what we're saying from others, but winds up concealing it from ourselves. We have in place officials who have absorbed the following facts. They absorbed the first World Trade Center bombing in 1993. They absorbed the attacks on our military facilities, the 12-bar towers in Saudi Arabia that killed 19. And they refused to use the word terrorism to describe what we're up against. And so we have phrases that are substituted to describe reality and appear to be meant to conceal it. Instead of a war, we're told that what we have is foreign contingency operations, and instead of terrorism, the person in charge of Homeland Security refers to man-caused disasters. That kind of linguistic anesthesia makes it a lot easier for the Attorney General to make an announcement that this was what he did. And the response of the administration, the shooting at Fort Hood, was of course initially we must come to conclusions. Just as we had in place protocols for trying defendants before military commissions, so too we have in place protocols that permit the FBI to gather intelligence and to open investigations. However, those protocols do not permit the opening of investigations based on First Amendment activity alone, and a great deal of what Major Hassan did before the Fort Hood shootings was First Amendment protected activity. That may well be something we have to rethink, whether there's a difference between an investigation undertaken for the purpose of gathering intelligence and an investigation undertaken for criminal purposes. May provide a basis for that distinction. And I'm not arguing jurisprudence here tonight. That's premature. But I think we have to to abase ourselves and to make ourselves less safe. We're in a city where the United States actually was winning because it was the treaty in Paris that finally ended the hostilities between us and Great Britain. And this is a highly appropriate place, I think, for us to think about what the United States has to do to make sure that that continues to survive, given the fact that we're in a city where it was won. Thank you very much.
And we'll go as long as we can. We've got probably 15, 20 minutes maximum for that. Keep your questions short. Please don't make a prefacing statement. Ask a question. We want to hear what he has to say. And if you want to ask a question in French, we'll help you get it translated into English. All right?
My French is not very good.
Who has a question for General Mukasey? I'm shocked. I thought that. Go ahead.
Thanks, Judge. Judge, are you concerned, given the fact that your successor has, the policy of the government is that waterboarding was torture and that KSM was waterboarded 183 times, notwithstanding whatever untainted evidence they may have against him? Are you concerned that your peers on the Southern District may just say that governmental misconduct and throw the case out? Is that a possibility?
There are a couple of questions working on that. I'm not concerned about his initial comment before the board was torture, because somebody asked him later on. But what about SEER training? SEER training is something that's undergone by Navy SEALs and by Army Rangers. It stands for, I think, for survival, escape, evasion, resistance, and escape. SEER for short. They are, among other things, waterboarded. And so, obviously, if waterboarding is torture, then anybody who did it is guilty of torture. As it happens, torture is a specific intent crime. It's a crime which says that if somebody acts with a specific intent towards severe mental or physical pain or suffering, those are the words, severe physical or mental pain or suffering, with the intent to do that, then they're guilty of torture. So it would depend, I would think, if we've been according to him later on in his testimony, there was much of an intention of somebody who did it. So far as throwing out evidence, I would throw out evidence gathered after the waterboarding simply because it resulted in coercion, regardless of whether you call it torture or not, and because obviously he wasn't administering Miranda rights beforehand. However, the question then becomes whether spontaneous statements made months later, whether, for example, the letter to his wife, where he said that he thought it was frankly a modest achievement to have killed 3,000 people, and he couldn't understand what all the fuss was about, whether a statement like that might be admissible. That's a whole different story. So I don't think the evidence